there is a continued mixed reactions to Belgium's backing of South Africa's genocide case against Israel at the International Court of Justice. The European nation is the 7th country to officially join the case against Israel for its continued bombardment on the Gaza Strip. For more on what this means for the case, I'm now joined by the University of Johannesburg Professor of International Relations, Hennie Strydom. Prof, thank you so much for your time tonight. Belgium filed a declaration of intervention in South Africa's case against Israel at the International Criminal Court. They are focused mainly on the definition of specific intent required to establish genocide. How important is this?
Yeah, good evening. Just a small correction. My subject is international law, not international relations, so I will speak on the subject from that point of view. It's important to take, first of all, into account that about 10 states have now submitted declarations in joining the case against Israel. And they are entitled to do so because of their membership as parties to the Genocide Convention. And states who are members of the convention may submit declarations in joining cases of this kind in order to assist the court in coming to a conclusion, although they are not part of the case itself, which, as we all know, is between South Africa and Israel. So there is a common sort of feature amongst the declarations of the declarations submitted to the court at this point in time, and that is that they concentrate on the interpretation rules that should be applied in giving meaning to the different provisions of the Genocide Convention. Yeah. So, and most of them are on agreement on that. So I think that is the important part of it. So we have 10 states submitting the same kind of evidence and having the same kind of approach to the interpretation of Genocide Convention, which is now before the court.
Does this, Prof, in any way then bolster South Africa's case against Israel?
Well, all the states who have submitted declarations have done so, either one of them even explicitly, the others by implication, are in support of South Africa's case against Israel. So, but they're not sort of focusing on all the other issues that South Africa raised when it brought the application to the court. Their role and their purpose and objective are simply to tell the court we are of the opinion that when the court assesses the evidence, assesses the facts before the court, the way in which the court must interpret the Genocide Convention, in our view, is as follows. So I think from that point of view, they want to put a certain interpretation before the court, assisting the court in coming to a conclusion. And I have to also add that what they sort of present to the court is based on established law, which is well known and also well known to the court. So on that score, they are in agreement with the case that is already served before the case. What we must not forget, though, is, and I think that's an important factor, is that Israel must still submit its memorial or counter-memorial to what South Africa has submitted on the merits of the case, because we are now past the interim measures. And Israel has already requested on 2 occasions an extension of time. And the latest is that they have to submit by March 2026, that's next year. Yeah. So it's only then that the court will then start assessing all that is before it at this point in time to come to a conclusion.
Prof, as you've already said that there's about 10 countries here, right? They include Spain, Brazil, Ireland, and Mexico that have joined the case. But I'm curious, though, on how different is this intervention that Belgium is seeking compared to the other countries?
I don't think it's that much different. Substantively, it deals with the how to assess the direct intention issue that is part of the Genocide Convention's requirements for finding that there was, in fact, a genocidal intent.
Yeah.
And it has submitted, substantial evidence for that, case law, etc., which the other countries have done also. So I don't think there is a, fundamental distinction between what we have at this point in time.
Prof, I was reading that Belgium is not fully endorsing South Africa's case, but then I'm wondering if they're not entirely endorsing South Africa's case. What are they trying to achieve?
Well, you must understand that I think it is something that we have to take into account is that there might be certain variations in the different approaches of the states that have submitted declarations. Here and there, nuances of interpretation and approach and so on. But what is important is that is only one aspect that the court will take into account. The court is definitely not bound by what the states have presented at this point in time. So there's a whole spectrum of legal principles, of facts, etc., that will eventually be assessed by the court, holistically looking at it and objectively. And then the court will come to a conclusion. So I don't think that what the states have presented here to the court will play a fundamental role in the decision eventually. It will, of course, be important for the court to take into account what the different states have submitted to it. But eventually it's for the court to decide what is the correct application and interpretation of the Genocide Convention, taking into account the facts before it.
University of Johannesburg, Professor of International Law, Hennie Strydom, thank you so much for your time tonight.